contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
Right out the gate. An oath, no contact, no proxy calls, sign it or face contempt. While downstairs the jail logs allegedly show hundreds of calls to the complaining witness. Today's docket reads like a how not to. Terroristic threats, evading, DWIs, GPS violations, and a defendant who may or may not be calling a victim 300 times. Stick around. We'll unpack who's protected, who's punished, and why procedure matters.
Witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules, et cetera, et cetera.
Good.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? Okay, so you want to set it for Monday?
Sure.
Okay. But just get it as soon as you can, get it to them. Have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that it truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
He in the last time, he used someone else's SPIN number to make the phone calls.
That was last
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just before we tell the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. You understand?
Good.
Okay. Thank you, Judge.
Thank you.
Thanks, guys. See you Monday. Good morning.
I'm Mr. Arroyo on your in-country docket.
Okay.
We're here for a bail order.
And for what it's worth, you don't really have to approach. The only time is if you need something, then just for, it's a high bond, huh?
It is, Your Honor. We are requesting a PR bond.
Say it again.
We are requesting a PR bond, so.
Good morning, Mr. Arroyo. How's jail? Fun?
I'll say.
So February, you have a terroristic threat with us of a family or household member, and now you've picked up an evading arrest in a motor vehicle. While you're on bond for this case, you pick up a serious third-degree felony. What happened in a terroristic threat?
There's a threat, Your Honor?
The terroristic threat in our case, please.
In our case, on February 3rd, 2025, an officer responded to a weapons disturbance at a residence in Harris County, Texas. The officer met with the witness who stated that her granddaughter's boyfriend, the defendant, was upstairs in the house with a gun. The witness stated there were 5 other people in the residence and everyone exited the residence safely except for the defendant. Officer met with the witness who stated she had been dating the defendant for 3 years and broken up with him hours before, and the defendant left the residence. When it was asked the defendant wanted to retrieve some items, and the defendant said no. The defendant came back to the residence, and the complaining witness refused to let him in. Short time later, the defendant sent the complaining witness a picture of him inside her vehicle, pointing a handgun at her bedroom window. The complaining witness saw a laser through her bedroom window, which she knew was attached to a handgun that he owned. The defendant threatened to kick her door down and make forced entry into her home. The complaining witness still refused, and the defendant began hitting the windows around the house and screaming the complaining witness's name. The complaining witness called 911 and went inside a different bedroom.
Something out of a movie, like a horror movie.
A second witness, the uncle, led the defendant inside the residence because he was unaware of the break-in. The defendant went straight into his room. The officers tried to make contact with the defendant but were unsuccessful. The defendant was identified by a photo and date birth.
So tell me what happened now in the new, please, in the evading.
Yes, Your Honor. On April 2nd, 2025, a law enforcement officer was dispatched to a vehicle in reference to a discharge of a firearm. While searching the neighborhood, the law enforcement officer made contact with the witness who advised that the driver was a Hispanic male with light bushy hair, and the vehicle had a plastic wrapping around the rear window with one laminated tail lamp. Law enforcement officer continued to search the neighborhood and observed a vehicle that matched the description. Law enforcement officer made a U-turn and pursued the vehicle. As the law enforcement officer approached the vehicle, the driver accelerated speed and disregarded a stop sign.
Tell me they found a gun.
The law enforcement officer do not have that uniform. The law enforcement officer initiated lights and sirens to stop the vehicle, failed to stop, failed to stop, accelerated speed, and disregarded multiple stop signs for approximately 3 minutes and around a mile and a half of roadway, reaching a speed of 62 miles an hour. There were multiple areas the defendant could safely stop, and the defendant stated he evaded because he believes he had an open warrant for family violence. I
Was this
believe
in warrant status? Do we know?
this wasn't warrant status, Your Honor. Let me.
It was a 2B, Your Honor. It was a 2B that was filed. It wasn't so I think they're speaking about the terroristic threat family violence in our case. And it was filed as a 2B. He never was arrested on it or didn't have a court record.
You know, Mr. Arroyo, you need to think that in this world, when you go to jail, you now know you have no one that's going to pony up money to get you out. So when you go to jail on charges, you are stuck unless someone's right. Since January, you've had an unlawful restraint, an assault of a family member. Now you have these two open cases. Why would we continue to give PR bonds?
If I may, Your Honor, the two previous cases, the unlawful restraint and the assault family member, the file date was back in 2023. He had it set for a jury trial and it was dismissed. He never bond forfeited.
You represent him on this case?
I did not. I was just appointed today to him. But I'm just looking at the procedural posture of the case. He does not appear to be a flight risk of any kind. He took those cases and.
Well, I mean, he's evading capture now with the police, you know? Something's going on with you, man. I don't know what's going on, but who do you have in your life? Who's around to give our mom, dad? Who do you have? You got a son? What? You're a baby yourself. How the hell? I mean, do you live with mom?
I live with my mom.
Well, that's what I'm asking. Who do you live with?
Yeah, I live with my mom.
Do you actually live there or are you out on the street all the time?
I actually do live there. I stay there and I take my sisters to school in the morning and pick them up after school. And I work and I take care of my son every day that I can when I'm not working. And he sleeps over if I'm not going to work the next day. That's all I'm really doing. But
In the last couple months, you've had 4 charges. What do we need to do to ensure you don't pick up a 5th?
He is now living with his mother. It sounds like before he was staying with the employment. So the change in location is going to be helpful, certainly. He now has employment. He works at Cosmic Air.
Let's do this. If you can, is mom here? No.
I don't believe
No,
so.
sir.
So let's do this. If you can verify that she will actually take him, because I'm not giving you a PR bond or even a bond reduction for you to just go out on the street.
Sir.
If I let you out, I'm putting you under very strict rules. No dope, no alcohol, and I'm going to test you like crazy. Does he have a license? You're not allowed to drive. I don't care what you got to do. I don't care about your little brother having to go somewhere or your son. If you don't have a license and you don't have car insurance, then no driving. That is a bond condition. I'm going to have you sign an affidavit promising you. If I find that you do, I can have a contempt hearing an additional 6 months. But I'm not letting you out unless you have a stable place to go to, because I don't want you out on the street. Nothing good. And I'm giving you a curfew as well. You understand?
Sir.
I'm going to put a monitor so I know where you are at all times, and then we'll talk. But first things first, not to the street. If you can verify that he's got a place, then let's talk. And I'm happy to do something.
Thank you very much.
Yes, ma'am. Yes. Good morning, Mr. Bustamante.
Good morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You now also have an immigration detainer. I will tell you that when you show up to court, good things happen. This doesn't have to happen. But when you continue to miss court, this is what happens. You ever pick up another charge, come to court.
Venga a la corte.
It's not a bad thing.
No es nada
You
malo.
understand?
¿Entiende?
Now you will end up with a conviction on your record. This DWI will go on your record. It will be there for the rest of your life. If you ever get into a car and drive and you have the smell of anything funky,
Pero
it's
no,
probably not going to go well for you. So I would never, even if you've had a sip of alcohol, get into a car and drive.
en un carro y manejo.
After today, you will now be facing a minimum of 30 days in jail for any new cases that you pick up.
En la cárcel cualquier nuevo caso.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do?
Quería hacer.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to sentence you to 30 days in jail. I'll give you credit for the 90 days, the 19 days that you've done. I'm now going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir. Is your guy here?
Yes, sir.
Bring him up.
No, not at all. We have a disconnect on the reinstatement fee. Is the court requiring the reinstatement fee? I was told.
I'm not going to. I want to admonish him.
Oh, yeah, okay, cool,
Hey,
cool. Mr. Fairfield, yes,
Pause
yes.
here. The judge isn't bluffing. When a court has evidence or strong allegation that a defendant is harassing a complaining witness, an affidavit and an oath become powerful tools. They create a legally binding, swearing under penalty promise not to contact the victim directly or through third parties. From a legal perspective, that sworn promise converts ordinary behavior into potentially contempt-level misconduct if broken, punishable by jail and fines. But there's a procedural tension. The defense warns that putting someone in segregation to stop calls can strip away attorney-client privacy and impede preparation on serious felony matters. That's not a hypothetical. Recorded visits and restricted calls can chill defense strategy. So the judge is balancing victim safety against the defendant's constitutional and counsel access rights. For viewers, do you think a sworn affidavit plus monitoring is a fair middle ground? Or is segregation the only effective remedy when calls persist? Tell me why.
Yes, yes, we.
No,
yeah,
I'm
yes.
not. No, I was going to grant it regardless.
Okay, cool, cool. Okay, it was a disconnect that he came to us. Come over here, Mr. Fairfield.
Oh, yeah.
He's already in PTI.
Okay, great. He already has an interlock, right?
Yes, sir.
Okay, so you need to understand a couple things, that this license right here is on my name. You are only allowed to drive a car that has an interlock on it. This doesn't give you an open license to drive any car, only ones that have an interlock on it. Do you understand?
Yes, sir.
You also need to pay that reinstatement fee. If you do not pay the reinstatement fee, this is only good for 30-something days, perhaps 45 days. You have to get in full compliance with DPS, and then they will extend this for the full life of the suspension, which is 90 days. If you don't pay the reinstatement fee, probably after 30, 45 days, this is not going to be valid, not worth of anything. Do you understand? So I would probably pay the reinstatement fee as soon as you can. Okay, done.
Thank you, Your Honor. Yes,
All right.
Have a seat, Mr. Fairfield.
sir.
I'll bring it. Thank you.
What's new?
I've got a new case today, Mr. Romero Bennett.
Okay. And get her.
I believe he has, and
Okay.
so I talked to pretrial. He got tested already today. I know he's kind of told you he's on oxycodone, which he is prescribed, and so he wanted me to at least present the prescription
I cannot
information.
believe that they're still prescribing it. You're telling me they still prescribe Oxy?
I
They
mean,
went bankrupt, didn't they?
oh, I don't know about that.
Yes. Yes, the pharmaceutical company that makes that OxyContin, they went bankrupt. They got sued. They declared bankruptcy. I guess let me see what you got.
I think I'm very generic.
I'm telling you, I don't know. Maybe
Like he
I
has the
know that they
bottle
went bankrupt.
and here's the prescription.
How many pills did he actually get? How long ago was this? I cannot believe that they would prescribe this many. This is like an actual death sentence. It's like, this is freaking, this is like begging someone to get addicted to this shit. This is fucking nuts, man. These people. I'm not giving you an open ticket to use that, which is it's a literal death sentence. The problem is, Mr. Bennett, and I don't know if you realize this, but I can't tell you how many friends I've had that have died because what you do is you build up a powerful addiction to this shisa, and what happens is you keep taking, you put your lungs to sleep because of how powerful this thing. The addiction is so powerful that people convulse trying to get off. Seize.
I brought it just because it was in my system, just so you don't think I'm abusing it. And I'm pretty sure my levels are down on what was in my system on the 4th.
I'm not going to ding you on it now, but I want it to stop. And I'm not going to continue to let you use. So
You told me since the 4th.
great. I don't want you to. I'm still going to test you for the foreseeable future. If I know that you're done and you're not using, then I'm happy to modify it. But I want to know that you're not using. And this stuff is so powerful that I'm scared to just take off and not test, right? So I'd like to do it for some time. If he's clean for a while, then I'm happy to take off. But I just don't want you to die. That's all I want, you know, or you take someone else on the way, you know, you just can't, it's so powerful. I can't believe that they would prescribe that much, that many, he tests today
Yes, Judge.
and,
So the THC and oxycodone.
okay. We need to figure out when it's going to stop. I'd like to know how many are left, you know, so we can build a plan to when I know it's going to stop. I'm not going to continue to let you use. Like if I see it in 2 weeks, I'm going to have a problem with it. I'm going to tell you now. So I just be safe. That's all I'm asking you to do, you know? All right. We'll reset you. I'm going to test them next week at some point, and then we'll see how it goes.
Judge, we're still doing Monday, Thursday?
What do you want, Maverick? I want to test them at least once a week.
Once a week is fine.
So-
So I don't know what days you like to do.
Well, I'm going to do it random.
Oh.
That way he doesn't know, because if he knows, he can prepare. So
Okay.
that's why. It's at some point next week, we'll call him to test. Okay, just be ready. Don't use, man. Don't. I'm giving you the opportunity now for you to stop on your own. Do you understand, Mr. Bennett? All right, man. Good luck. Okay, thanks.
Judge, for Mr. Frederick, you'll see that a bond violation was submitted. They were given conditions by the magistrate with the GPS exclusion zone of the residence that they live. So that hasn't. been
But we also need
addressed.
to know whether the complaining witness lives there too.
Yes, I just wanted to make it, bring to your attention that although it's
Okay.
arraignment, he does have a bond violation from the magistrate's condition.
Okay, thanks. You are Christopher Frederick?
Yes, Your Honor.
Mr. Frederick, you're charged with assault on a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay, morning.
Good morning, Judge. Thank you. On March 31st, 2025, so the law enforcement officer made contact with the complaining witness who stated the defendant is her boyfriend. The complaining witness stated that they got into an argument over the defendant and the complaining witness both stating they would break furniture. The complainant was stated that she was going to walk out and the defendant got into a fighting stance and struck her in the face with a closed fist causing pain. The officer observed the complaining witness left side of her face to be swollen.
So what you say, he said just struck her in the face?
Yes, Your Honor.
Mr. Frederick, I'm going to find that there's sufficient probable cause to go forward with the case. There are bond conditions that the magistrate placed on you. If you fail to live up to those conditions, if you violate those conditions, a warrant for your arrest will be issued. You will go to jail. No more PR bonds for you. Do you understand? I'm going to do everything in my power to protect my community at all costs. I don't care who you are, what color you are. If you're a small farm animal, if I find that you violate these conditions, I don't care what your excuse is, you will go to jail. So, Felicia, tell me, what conditions is he alleged to have violated?
It's the GPS exclusion zone. He has a GPS device with a curfew as well as an exclusion zone for the 12,000 Martin Luther King Boulevard address.
Okay.
However, it also seems to be the resident commissioner's office.
Okay. Have you guys done a rip on this case? Do you know?
I believe we've attempted one, Your Honor, but we've not made contact yet. Or I'm sorry, I apologize. We have made contact now, Your Honor.
What does she want? Does she want to have contact with him? Does she not want him to go back? Mr. Frederick, do you have the ability to hire a lawyer?
No, I don't.
Okay, I'm gonna need you to fill out an application for me. I need to know whether you qualify. We don't just give out court-appointed lawyers like it's candy. You have to qualify for it. So what we'll do is Deputy Miranda's gonna give you an application. I need you to fill it out. I need to know everything about you, what money you have in the bank, what kind of money you make, what kind of job, cars. Let me take a look at it. I'll see whether you qualify. Do you currently have a monitor on you now?
Yes, I am.
You are not allowed to go back to this house. I don't know whether she wants to have contact with you until I know. I'm going to honor these bond conditions. Do you understand?
Yes.
Okay, so let's first see if you qualify for a lawyer. If you do, I'll give you a lawyer and then we can go further. Deputy Miranda is going to give him an application. I'll have you sign a reset and then we'll have you take a seat in the jury box.
Go ahead.
Your Honor, this is like you said. They were living together and they no longer live together. I'm not sure if that means she moved out of the residence and she lived in the residence.
See, maybe we can get it done a little bit later today. To see.
Yes, Your Honor.
Just my approach. I just want to let you know, the seal of the pretrial had already come and told us that she no longer lives there.
Come on. We took all your conditions off. We took off all your conditions. We took the GPS monitor off. We took the curfew off. Just the restriction for you to go back home. The only thing I'm asking you to do is don't have contact with this person. Okay, we took everything off. Go live your life. Just don't have contact with this person. Don't be in possession of weapons. As long as you can have that, I'm happy. And then just live your life. Don't get in trouble. You know? Okay, we're giving you a lawyer. Just you need to stay in contact with them. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Harold and he'll tell you if and when you have to come back to court. Okay? Okay, man. Have fun.
Thank you, Judge.
You are Ernesto Hernandez.
Andes.
See,
Yes.
Mr. Hernandez, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, será
You
usado
have the right to have an attorney represent you. If you cannot afford one, one will be appointed to you, sir.
para hacer.
Okay.
No
Judge,
diga nada, escuche.
on March 31st, 2025 in Harris County, Texas, law enforcement officer was flagged down by the complaining witness who stated that a vehicle was driving the wrong way down a one-way street and damaged the complaining witness's vehicle and did not attempt to stop. The complaining witness stated he followed the defendant to a dead end and called the police,
No te lo
then
siguió
found the
hasta
law
una calle
enforcement
sin
officer.
salida.
The complaining witness then showed the law enforcement officer where the defendant's vehicle was
Let's
parked.
break down the enforcement mechanics. This is where theory hits reality. Courts can and do impose strict bond conditions. No driving without insurance or license. GPS exclusion zones, ankle monitors, random drug testing, interlock-only driving, curfews, and signed affidavits promising no contact. These are not suggestions. They're enforceable conditions. If you ignore a no-drive condition and crash, or if you violate a no-contact oath by using a family member's phone to call the victim, the court can move quickly to revoke bond, order contempt hearings, or even impose additional jail time. On the DWI/interlock side, failing to pay DPS reinstatement fees or driving without an interlock can trigger administrative suspensions that cascade into criminal exposure. And on the custody/segregation side, jail administrators can block specific numbers or, in extreme cases, segregate a prisoner to stop calls, but that action is blunt and affects counsel access. The practical takeaway: Compliance isn't just ethical, it's your legal lifeline. Would you trust strict monitoring and affidavits to protect victims or demand criminal contempt and segregation when the alleged behavior continues? Comment
This
below.
vehicle was parked.
Dice en el
The
sitio
law
donde
enforcement
estaba
officer found the defendant
estacionado el
asleep behind the
vehículo,
wheel of his
que estaba
vehicle.
dormido detrás del
The
volante
complainant
del
was able to
vehículo.
identify the defendant as the
La
individual who was driving the
denunciante pudo
vehicle at the
identificar
time the
al
damage
individuo
occurred.
con
The complainant
que
witness
estaba manejando
estimated
el
the damage
vehículo
to
cuando
be
hizo.
$802,000.
Estimaron que el daño, I'm sorry, the amount
$800 to $1,000.
de entre 800 a $1,000.
So he hit the vehicle and
Así
took,
que él le pegó al
Yes,
vehículo
hear that, and how far did he go?
y que tanto
I'm not
siguió.
sure.
Dice, no estoy seguro.
It occurred near
Eso ocurrió cerca de
340 South 69th Street.
342 Sur,
And then there
calle
was a dead
69,
end
entonces
at
se llama la calle sin
that
salida,
the defendant was parked at
donde
300
estaba
South
estacionado el
7th
acusado,
Street.
cerca de la calle 70.
Read the part where the accident,
Dice,
please, if
lea
you don't
la
mind,
parte
into where he took
cuando
off.
tuvo un
Yes,
accidente
Your Honor.
hasta dónde.
I didn't hear it.
Complainant stated a
El
vehicle was
denunciante
driving
dijo
on
que
the
un
wrong
vehículo
way
iba
of a
en otro
public
sentido
roadway.
en una
That
carretera
is a one-way
pública,
street.
que era una calle de un sentido.
And the complainant stated the defendant
Dijo que el
damaged
acusado
his
dañó
vehicle
su
when the
vehículo
defendant was driving the wrong
cuando
way and did
estaba
not attempt to
acusado,
stop.
estaba manejando
has
en
the
una vía en
difference,
contraria. Entonces no paró de información.
And then he goes to a dead end street
Es una calle sin salida.
Yes, Your Honor.
Sí, sí.
and falls asleep.
Yes, Your Honor.
Do we know if alcohol is a factor?
Ha consumido
It's not
alcohol.
alleged, Your Honor.
No se alega eso, su señoría.
I'm not sure that there was any
No estoy
investigation.
seguro si hubo una investigación.
Mr. Hernandez,
Señor
I'm
Hernández,
wondering if there's
puede
sufficient
encontrar
probable cause to go
suficiente
forward.
causa para seguir hacia adelante con su caso.
On his license, please.
Yes, Your Honor.
If you do not have a Texas driver license and liability insurance in your name, you are not allowed to
No se le
drive.
permite manejar.
Do you
¿Lo
understand?
entiende?
If I find that you do,
Usted
I will put you in jail.
vamos a meter a la cárcel.
His license is eligible.
I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you,
Uno
they can
encuentra
possibly put a detainer on you and you will be stuck like Chuck in there
como yo.
until this case is over with. Do you understand?
¿Lo entiende?
It
Yes.
is a bond condition that you're not allowed to drive unless you have liability insurance as well. Do you have the ability to hire a lawyer?
Has de contratar un abogado.
Sí contraté uno.
Yes, I hired one,
No, no ha llegado, yo creo, no sé.
but he hasn't gotten here. I don't think so. I don't know.
Oh, Judge, I
I
they
don't
called
see-
this morning and they said that the attorney had to go to a different court, but he was going to be on his way. And
Do they
they thought they were
identify
following up.
who?
La oficina.
See anything filed
Yes,
there?
yes.
Oh, you do? Who is it? So I don't see it. That's
It is Mr. Pass.
David Pash. Okay. So what we'll do now, Mr. Hernandez, is I'm going to have you sign a receipt, Victoria. We will have you take a seat at the jury box while we get your bond conditions. We will also wait until your lawyer arrives.
Su abogado.
Please, do you mind filing no driving without both?
Yes, Judge. Your Honor.
Good morning, Mr. Shea.
Good morning.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I'm sorry, I didn't step.
SHA.
On March 30th, 2025, in Davis County, Texas, an officer was dispatched to a family disturbance call. The officer met with the complaining witness who stated that the defendant is her husband. The complaining witness stated that the defendant and her son, who has mental health issues, got into an argument where the defendant slapped her son in the face. The complaining witness then intervened by getting between them. The defendant then grabbed her by her hair and pulled it, causing pain. The defendant then left to the garage, saying that their children would grow up without parents.
Judge, if I may, they did a rip call, and in the rip call, it indicated that she didn't feel any pain.
Judge, let me clarify what the recall says specifically is that she got in between them and he grabbed her hair a little bit. The defendant was reiterated that this hasn't happened before and that she was not hurt. Does not say she didn't feel pain, just that she was not hurt.
Did the officers ask whether she felt pain at the time?
The judge says that the complaining witness stated that the defendant grabbed a hold of the complainant's hair and pulled it hard, causing her to feel pain. That's as the injury.
It does say that.
It does say that the injuries grabbed a hold and pulled it hard.
Mr. Shape, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know whether she wants to have contact with him? A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up.
The complaining witness is asking to drop charges and to drop whatever bond conditions exist, Your Honor. I don't know if that's.
So what I'm going to do is I'm going to order you not to have any threatening or harassing contact with this person. If I find that you do, I will revoke your bond and put you in jail. You need to understand that what is threatening or harassing doesn't matter what you think. I could care less what you think. It's what she perceives. Do you understand?
Yes, Your Honor.
And you've got a lawyer. The lawyers will take care of you. I will waive your appearance so you don't have to waste your time coming to court, but stay in touch with them. They'll tell you if and when you have to come back to court.
Thank you, Your Honor.
Do you mind filing no threatening or harassing conduct?
Yes, Your Honor.
And we can amend the MOA for you as
This
well.
hearing shows how courts use a layered toolbox, sworn affidavits, bond conditions, GPS/monitors, interlock devices, and possible segregation to protect victims and manage dangerous patterns. But the system must tread carefully. Enforcement should be proportional, preserve counsel access, and ensure records, call logs, jail records, toxicology, are produced so fact, not rumor, drives decisions. For defendants, the message is blunt. Respect orders, stay in touch with counsel, and comply or risk rapid escalation. For victims, timely access to records and clear protections are essential. If you found this breakdown useful, hit like, share your opinion below, and subscribe for more courtroom deep dives. We dissect the law so you don't have to.
The MOA for you as well to take off the residential restriction.
Thank you, Judge.
All right, sir. So what I'll have you do is we'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We're going to get bond conditions created for you. Once you sign them, after that, you'll be free to go. Do not leave until you sign the bond conditions, though, sir.
Thank you.
Okay, thank you.
Thank you, Judge.
Good morning, Mr. Reyes.
Morning.
Sir, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, a law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of South Highway 6, turning left. The law enforcement officer turning left at a high rate of speed. The law enforcement officer made a U-turn at the intersection to follow both motor vehicles having to travel approximately 66 miles an hour in a 40-mile-an-hour zone. The law enforcement officer observed the motor vehicles to be side by side with the Honda flashing emergency lights. Law enforcement officers observed the Honda turn off its lights, and both motor vehicles began to speed up again while driving side by side and run a red light. The law enforcement officer attempted to catch up to both motor vehicles, causing the law enforcement officer to travel approximately 90 miles an hour in a 40-mile-an-hour zone. The law enforcement officer briefly lost sight and reobserved the Silverado as the motor vehicle continued traveling eastbound. A traffic stop was initiated, and the law enforcement officer made contact with the driver. The defendant stated, when asked about the high speed, no, I was on my way home with my friend Adam, and Adam was following me home. Co-defendant arrived claiming he was there to check on the welfare of the defendant. Co-defendant stated I was flying home, but I broke off because I wanted to get something.
So we do have a co-defendant?
I believe.
You know?
One check.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? If he has a license.
Yes, Your Honor. And we do have the co-defendant in this case. Got it.
I'm ordering you as a condition of your bond not to participate in this type of activity anymore. You're not to race, do any street takeovers, donuts, driving maniacally. If I find that you do, I will take your privilege to drive away from you, and then I'm going to put you in jail. Do you understand?
Sir.
I'm not asking much from you. I just want my streets to be safe.
Eligible, Your Honor.
Okay, you're also not allowed to drive unless you have liability insurance in your name. All those are conditions of your bond. You violate that, it's not going to go well for you. You understand?
Sir.
Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Roth and he'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you because you're playing games, likewise, I will revoke your bond. We'll have you sign a reset with Victoria. We'll have you take a seat while we get your bond conditions. You'll sign it and then you'll be free to go, sir.
Yes, sir.
Thanks. Thanks. Take care.
This one was CHA. We're